What are the latest XRP news? How much will XRP cost after the trial? When will the result of the trial be announced? We will answer all these questions in today's video. In 2020, the U.S. Securities and Exchange Commission charged Ripple and its executives with violating securities laws by selling XRP to finance its operations. It claimed that the blockchain payments business failed to register the asset with the commission. The long legal struggle is finally coming to a conclusion after more than 2 years. CATHIE Wood, CEO of ARK Invest, has commented on the case's conclusion. She feels the SEC is on the verge of losing the lawsuit. She does not, however, explain why she feels this is the case. It seems the SEC could be on their way to losing that as well, Wood said in a recent interview highlighting previous court setbacks for the agency. It is worth mentioning that recent court decisions tend to favor the blockchain payments provider. As previously reported, Ripple Chief Legal Officer Stuart Alderodi said that the company's confidence improved with each verdict after Judge Analisa Torres' decision on Dobert arguments. Ripple has also recently filed letters citing different court opinions in support of its fair notice defense. The SEC has now replied to these letters, as previously reported. Nonetheless, analysts remarked that Ripple's arguments were not harmed by the response, especially when it came to remarks from the judge in Voyager's bankruptcy case. Attorney John E. Deaton, who is representing thousands of XRP holders as a friend of the court in the legal dispute, has warned community members to anticipate a judgment on so-called summary judgment in the coming weeks. Significantly, Wood's most recent words were in response to questions concerning the feasibility and timeframe of a Bitcoin spot exchange, traded fund, ETF in the United States, which has been authorized by the Securities and Exchange Commission, SEC. The ARK Invest CEO blasted the commission for being inconsistent in approving Bitcoin ETF products, citing remarks from grayscale appeal judges. Judges questioned why the same fraud safeguards were adequate for the SEC to approve a futures ETF, but insufficient for a spot ETF, as stated in a prior article. As a result, Wood anticipates that Grayscale will get a favorable verdict in June. She said that the SEC would be forced to choose between closing the Bitcoin futures product it had authorized and approving the Grayscale spot authorized and approving the Grayscale spot ETF. Remember that Wood's ARK Invest, in collaboration with 21 shares, filed a Bitcoin spot ETF application twice. Both times, the SEC denied the offering, with the most recent rejection coming in January. Ripple Chief Legal Officer Stuart Alderodi responded to Coinbase's SEC Wells notification. SEC. A Wells notice is in SEC letter stating that a corporation or person violated securities laws. It gives the receiver 6 months to refute these charges before the SEC decides to take action. Coinbase received this SEC letter yesterday. According to Coinbase's Chief Legal Officer Paul Grewal's blog post, the warning gave Coinbase nothing to react to. The statement claims that an undefined part of the exchange's tradable assets, Coinbase Prime, and its self-custody wallet violate investor protection regulations. The crypto exchange was investigated last year. In a case against former Coinbase employee Ishan Wahi for insider trading, the regulator also alleged that 9 exchange assets were unregistered securities. Coinbase still trusts their asset listing procedure. Coinbase does not list securities, Gruhl said in the blog yesterday. In recent weeks, the crypto exchange has also asserted that its staking program is not an unregistered securities offering. In February, Coinbase rival Kraken settled SEC allegations by permanently ending its U.S. staking operation and paying a $30 million fine. Coinbase notes that the SEC authorized its operation and permitted it to become a publicly listed corporation in April 2021, days before SEC Chair Gary Gensler took office. In the previous 9 months, the company met with SEC investigators 30 times to register part of its operation and settle inquiries. Although Coinbase paid millions in legal expenses to identify viable registration models for Bitcoin, the SEC stopped the process in January. Gruel speculated that Gensler's numerous remarks urging crypto businesses to register with the SEC would fail. As reported in recent months, the crypto exchange seems to have been preparing for a showdown with the regulator. The crypto exchange recently revised its risk statement to clarify that it may not remove a listed crypto asset even if the SEC labels it a security until the regulator wins in court. Ripple is still fighting the market regulator on whether XRP is an unregistered securities. The blockchain payment startup got an amicus brief from Coinbase in its battle against the whole fledgling industry. If the SEC takes action, Consensys's lawyer William Hughes expects a flood of amicus filings supporting Coinbase. Alderity's responses and history suggest Ripple might support Coinbase. Hughes believed that if the SEC enforces, the court fight would go years and beyond Gensler. The attorney predicts that factual issues will lead to appeals. In July, CryptoLaw founder-attorney John E. Deaton called the SEC a compete complete and total disgrace. The regulator's actions angered and grieved the attorney. The attorney later tweeted that free marketeers would be disgusted by the SEC's actions. U.S. market growth is questionable. Once Terra and Fox collapsed, authorities, notably the SEC, seem to have initiated an industry-wide crackdown. Market players want unambiguous instructions. The crypto world is coming to the conclusion that the lawsuit between blockchain startup Ripple and the Securities and Exchange Commission, SEC, is just around the horizon. The decision of the lawsuit is likely to have a significant influence on the regulatory trajectory in the crypto markets, particularly on securities categorization. In the most recent update, pro-Ripple lawyer John Deaton predicted in a tweet on March 27 that the judge's decision will be issued within the next several weeks or possibly this week. According to Deaton, if the SEC prevails, there may not be much downside for XRP, since the coin has the best risk-reward ratio. Yet, if Ripple prevails, it will be evident that XRP is not a security, and the token will have an upside. A Fox Business article said that attorneys working on the case believed that the legal disagreement might be resolved in the coming days, raising the likelihood of a summary judgment date. Deaton, who thinks that the disputed Heinemann speech emails will be disclosed because they are judicial papers, has pushed the crypto community to see the lawsuit as an assault on the whole digital asset market, rather than just Ripple. In another development, defense lawyer James Fallon tweeted on March 23 that the SEC had submitted its answer to the Ripple defendants' papers requesting supplementary power based on the Bittner and Voyager cases. The letter included throwaway observations, paragraphs from the judge's concurring judgment in the Bittner case, and a bankruptcy plan confirmation order from the Voyager case, according to the SEC's response. It goes on to say that the defendants argue that the extracts support their fair notice claim, which the SEC disagrees with, and that there is no reason to reject the SEC's summary judgment request. In this vein, Ripple supporter lawyer Jeremy Hogan said that although the SEC's answer makes legitimate concerns regarding the Bittner case, the regulator's effort to argue against the Voyager judge's finding on the perceived uncertainties of the crypto sector is smirkable. He went on to say that, although the response overturns the Bittner verdict, the Voyager judge's decision still stands for Ripple. With both sides confident in their ability to win the lawsuit, one noticeable result has been the possibility of a settlement. Nevertheless, according to Australian lawyer Bill Morgan, a review of the SEC's response letter eliminates the likelihood of a settlement.